for the betterment of society, and I am SAEED. Ladies and gentlemen, we are going to talk today on a very important clause of the franchise agreement, that is the non-competition clause or non-competitive clause of the franchise agreement. What is the purpose of the clause and why it is very important clause in our franchise agreement? A non-competition clause is a standard provision commonly you can find in a franchise agreement. It serves to protect the interest of the franchisor by ensuring that the franchisees do not use the skill, knowledge, and the resources, including its brand capitalization, obtained from the franchisor for any purpose other than that strictly having been defined in the franchise agreement. The franchise agreement, on one hand, stipulates the lawful use of the franchisor's name, style, and the logo, as well as the business material information, in order to pursue the very objectives of the franchise agreement, whereas at the same time draws a red line that stops the franchising for its misuse or illegal use, which would otherwise warrant legal actions by the franchisor. However, being a contract expert lawyer, I shall strongly recommend that the following factors may be considered while drafting and negotiating a franchise agreement. Non-competition clause. This clause should only restrict activities that directly compete with the franchisor business. Overly broad clauses that prohibits a franchisee from engaging in any kind of business, whether related or unrelated, may be considered unreasonable and may not be sustainable. The geographic restrictions should be limited to the areas where the franchisor operates and has a substantial presence. Restricting a franchisee from competing in the regions where the franchisor has no interest might be viewed as excessive and may not be sustainable in the eyes of the law. Then the duration is also a very important point. The length of the period of the applicability of this non-compete clause is critical. While it's reasonable to restrict competition during the franchise agreement, however, post-agreement restriction must have a clear and reasonable duration, typically ranging from 6 months to 2 years. However, all depend upon the nature of the franchise business. To conclude, ladies and gentlemen, non-competing clauses of the franchise agreements are legally enforceable. So that was a brief on the subject of the non-competition clause in the franchise agreement. Drafting franchise agreements is itself a field of specialization. For further information, further your queries on the franchise agreements, you may contact our franchise contact expert lawyer at our WhatsApp, the email given in the description of this video. Thank you.